This is Chapter 3, Part 2, the adjudication process. Chapter 3, Part 2, Slide 12, discovery. It's a process where each side discloses what evidence and witnesses they will use at the trial. The prosecution must disclose both exculpatory, which is evidence of innocence, and inculpatory, which is evidence of guilt, to the defense. And that's Brady versus Maryland case that's precedence for that. The defense may refuse to disclose defendant's testimony. The defendant does not have to testify. That's the Fifth Amendment protection. Process can be formal if ordered by the court, or it can be informal. Bottom of page 63. Let's look at the idea behind discovery is each side should have ample warning of what the other side will present at trial. Let's look at the bottom of that paragraph. There are two areas where the U.S. Supreme Court has required discovery. One, this is interesting, the name of an informant must be disclosed when the true identity of this person is necessary for the defendant's case. Two, the prosecution must disclose any evidence it has that tends to indicate the defendant is not guilty. That is called Brady material because of the Brady versus Maryland Supreme Court case. Slide 13 is Brady versus Maryland. Mr. Brady was accused of murder and placed on trial. He admitted being involved but claimed Mr. Bobbitt had committed the murder. Bobbitt confessed to the police that he had in fact committed the murder. The police had him sign his confession. Brady was convicted, but his conviction was overturned on appeal. The rule became the prosecution must turn over all exculpatory evidence to the defense. Page 64 of your textbook. You can read that on your own. There are examples of items covered by the discovery rules in many states. Actually, I'll just hit them really fast. List of witnesses, recorded statements made by people on the witness list, itemized list of physical evidence, lab test results, reports made by expert witnesses, statements made by all co-defendants. That's just a example list. Let's look at slide 15, plea bargaining. Charging, bargaining. Negotiate a deal to limit the number or severity of charges before they are filed. Plea bargaining. To negotiate as to the number of guilty pleas, level, or charges or sentencing. Rationale, because it produces certain results for each side. There's a Boykin waiver where the defendant acknowledges he was informed of all of his rights and details of the plea bargaining before accepting. He wasn't coerced, wasn't tricked. Most cases do end in plea bargains. Let's look at page 65 of plea bargaining. Plea bargaining is a process where the prosecution and defense work out a deal. And we already talked about when you agree to reach, when the agreement is reached before charges are filed, that's called charge bargaining. And after charges are filed, that's called plea bargaining. And many factors, bottom paragraph, many factors are considered. And it really has to do a lot of times with the strength or the weakness of the evidence in the case. They'll look at police reports, witnesses, their credibility, how they may be perceived by the jury, what was obtained during discovery, what are the lab test results. They'll be scrutinized, and they'll try to guess which witnesses the jury will believe. That's why the prelim is so important. So to kind of get a feel for the witnesses, to see how they testify, how confident they are in their testimony, how prepared and organized they are, that's all really important. And that's why we talk a lot about courtroom preparation in our administration of justice courses, because preparation for court, organization in your work helps you be prepared for court so you come across as a strong witness, and that's very important for the credibility of the case that you're giving testimony to, and often results in plea bargaining. Slide 66, the U.S. Supreme, or not slide, but page 66, the U.S. Supreme Court has set the following requirements for plea bargaining. 1, the defendant must have an attorney during plea bargaining, if he or she would have the right to one at trial on the same charges. 2, no threats or promises can be involved. 3, the defendant must have notice of the charges and the elements of each crime. 4, the defendant must be informed of collateral consequences such as deportation if they accept the guilty plea. Prior to accepting a plea bargain, the judge must question the defendant and make sure that there was that they are in fact waiving their right to trial and right to confront their accusers and self-incrimination. That's a Boykin waiver. Slide 17, the trial, preliminary stages. Look at the chart on page 67 and you will see the stages of a trial. So after the jury is selected, you have opening statements, first by the prosecutor, then by the defense. But the defense doesn't have to give their opening statement right then. They can wait until the prosecution's done with their whole case. The prosecution then presents its case and has to establish guilt beyond a reasonable doubt. The defense cross-examines the witnesses, and the prosecution can redirect, and then the prosecution rests. Then the defense presents their case and calls witnesses. The prosecution cross-examines, the defense redirects, the defense rests. Then you have rebuttal, rejoinder, closing arguments. Under closing arguments, the prosecution goes first, the defense goes second, the prosecution goes again. Because they have to prove beyond a reasonable doubt, they get to go twice for closing arguments. Then you have jury deliberations, verdict, sentencing. So let's look at slide 17, jury selection. Voir dire. I've heard it pronounced many ways. I'm from Ohio, so I say voir dire. But if you're from France, you'd probably say voir dire or something more fancy. It's from a pool of potential jurors. Now you'll hear voir dire is used for selecting jurors. It's also used for questioning witnesses when they're expert witnesses. And so you'll hear voir dire throughout the whole textbook and its meaning and how it's used. But for this purpose right now, it's for questioning jurors and selecting them. It's certain questions and screening. And they look for any reasons to disqualify them, obvious reasons. Page 69 of your textbook gives you examples of questions that jurors are asked during voir dire, so you can look through that yourself. Slide 18, the trial preliminary stages. You'll have challenge for cause, a dismiss of possible juror. They might, either side could show prejudice or relationship to the trial witnesses or participants to have them removed. Preemptory challenge, it's a dismiss of a possible juror. The prosecution or the defense could dismiss a juror, but they have a limited number of those challenges. And it might just be they think that that juror is going to favor the other side. Slide 19. The trial, the courtroom. Controlling access to the jury. So there may be a seek to sequester the jury away from news. You'll hear that when there's a big news media coverage on a case, the jury may be sequestered so they're not involved in all that media hype. Courtroom participants, you'll have the judge, who's the trier of law and is neutral. You'll have the prosecution and the defense attorneys. You'll usually have multiple attorneys for both sides. You'll have a court reporter who makes record of the trial. The court reporter does not like it when you say, yeah, no. They want you to say yes, no, and they'll call you out on that if you're bad about doing that, so you got to watch that. Technology used to make accurate records of trials, and there's different machines for transcripts. Look at the diagram on page 71, and you'll see a typical layout of a courtroom. Slide 20. The trial beginning, you'll have opening statements, I mentioned that, given by each side. The defense can give theirs later when they get ready to start their case, and they'll talk about what they seek to prove. Page 72 of your textbook talks about, let's look at right above prosecution's case in chief. The defense has three options: give an opening statement immediately after the prosecutor, give an opening statement after the prosecution has called all of its witnesses, or they don't have to give an opening statement at all, which I think they would want to though. And when the prosecutor opens and starts to present their case, that's called the case in chief. And they have to establish every element of the crime beyond a reasonable doubt. And they ask their witnesses questions. That's called direct examination. And objections can be made during that process by the defense. I lost what slide I'm on. Okay, slide 20. Prosecution case in chief. The prosecution presents its case, has witnesses sworn in, direct examination of witnesses. The questioning cannot be leading. They should be not long narrations because they don't want irrelevant evidence.